Okay, so our session is now streaming live. Welcome to courtroom number 2 on round 4 of the Northern Colorado High School Mock Trial Regional Competition. On the bench, we have Judge Ellison. My name is Cyril Bittergar. I will be your courtroom monitor and Zoom host for the Bar Association. We will start today with a brief introduction of each individual in the courtroom. As I call out the roll, please introduce yourself along with your full name, your team code, team name, and if you're a witness, your character name. Scorers may add this information to their score sheet as we go through this, and we'll give the scorers an opportunity at the end to fill in any blanks on the names before we get into the arguments. We'll start with the prosecution. The attorney who's going to do the opening statement for the prosecution, please introduce yourself.
Good afternoon, members of the jury, Your Honor. My name is Camille Martin. I'm on the Minecraft team, and I will be doing the opening.
Thank you. And the attorney who's going to be doing the opening statement for the defense, please introduce yourself.
Ladies and gentlemen of the jury, Your Honor, I'm Sears Rowe, and I will be doing the opening for the defendants.
Thank you. And the prosecution counsel who will be doing direct examination for the first prosecution witness, please introduce yourself.
My name is Camille again, and I will be doing the first direct examination for the prosecution.
And the attorney who will be, the defense attorney who will be doing cross-examination of that first prosecution witness.
I believe that Team Zelda is still waiting for 3 of our members to be admitted.
Right, I see Haley Erickson, who's joining now. All right. Well, maybe we'll pause on the introductions until we have the full teams here.
This round is good to get started.
Okay, thank you. All right. Does it appear there are any team members yet to appear? I'm not seeing anyone in the waiting room. Do the teams recognize anyone not present?
I believe that 2 of our members are having some technical difficulties with entering in the password and everything.
Okay. Phillips is joining now. I wish I had some good hold music for everyone. But we'll just have to just bear on the silence. Excuse me.
Yes, my apologies. I believe we're just waiting for one member now, and I believe he should be in here soon.
Our last member is opening it up right now.
Okay. All right. We can proceed with our introductions. We had just heard from the attorneys for the prosecution and the defense who will be doing the opening statements. We also were introduced, I believe, to the prosecution's first, the attorney who will be examining the first witness, as well as the defense attorney who will be cross-examining that first witness. And we are now on to the prosecution's attorney who will be direct examining or doing the direct examination for the second prosecution witness. Please introduce yourself.
Good afternoon, Your Honor and members of the jury. My name is Isabella Jupiter from Team Minecraft, and I will be performing the second direct examination for the prosecution of the witness Kyle Kuzak.
Thank you. And the defense counsel who will be providing the cross-examination of that witness.
Good afternoon, Your Honor. My name is Ian Cameron, and I will be performing the cross-examination for Kyle Kuzak.
Thank you. And the prosecution counsel who will be doing direct examination for the final prosecution witness.
Good afternoon, Your Honor, members of the jury, Zoom host. My name is Sadie Forkner. I will be providing the direct examination of Jordan Markowitz.
Okay. And defense counsel who will be cross-examining that witness.
Good evening again. I'm Tirza Rowe, and I will be doing the cross for the detective. Thank you.
And if we could have the defense counsel who will be doing direct examination on the first defense witness. Please introduce yourself.
Hello, I'm Tirza Rowe, and I will be doing the direct examination for Avery Becker. Thank you.
And the prosecution counsel will be cross-examining that first defense witness.
Good afternoon. My name is Sadie Faulkner. I will be providing the cross-examination of Avery Becker.
Thank you. And the next defense counsel who will be examining the next defense witness.
Good afternoon. My name is Haley Erickson for Team Zelda, and I will be directing Professor Blake Van Owen.
And prosecution counsel who will be cross-examining that witness.
Hello again. I am Isabella Jupiter, and I will be conducting the cross-examination of Blake Van Owen.
Thank you. And the defense counsel who will be doing the direct for the final witness on the defense side.
Good afternoon again. I am Ian Cameron, and I'll be doing the direct examination for Taylor Perkins.
Thank you. And the prosecution counsel who will be cross-examining that witness.
Good afternoon. My name is Camille Martin, and I will be doing the cross-examination of Taylor Perkins for the prosecution.
Okay, thank you. And now we'll get into the witnesses. The first prosecution witness will please introduce themselves.
Good day, my name is Jordan Hawks, and I'll be portraying Alex Cifuentes on Team Minecraft.
Thank you. And the second prosecution witness, please introduce yourself.
Good morning, Your Honor, ladies and gentlemen of the jury. My name is Dylan Schneider of Team Minecraft, and I'll be portraying Kyle Cusack.
Thank you. And the final prosecution witness, please introduce yourself.
Good afternoon, Your Honor, members of the jury. I'm Katarina Schinkel from Team Minecraft and will be portraying Jordan Markowitz.
Thank you. And if we can have the first defense witness, please introduce yourself.
Good afternoon, everyone. My name is Abigail Pritchard, and I will be portraying Avery Becker, Team Zelda.
Thank you. And the second defense witness, please introduce yourself.
My name is Grace Phillips, and I will be portraying Taylor Perkins.
And our final defense witness, please introduce yourself.
Good afternoon. My name is Edith May Frodel, and I will be portraying Blake Von Owen for Team Zelda.
Thank you. And prosecution counsel who will be providing the closing remarks.
I will be providing closing arguments. My name again is Sadie Faulkner.
Thank you. And the defense counsel who will be providing the closing.
I will be providing closing for Zelda. My name is Haley Erickson.
Thank you. And if the prosecution timekeeper will please introduce yourself.
Good afternoon. I'm Rosa Fabian, and I'm the Minecraft timekeeper.
Thank you. And the defense team timekeeper, please introduce yourself.
Good afternoon. My name is Annika Thayer, and I will be the timekeeper for Team Zelda.
Great. Thank you, everyone. As a reminder, only the presenting attorneys, prosecution and defense, and the witness, so that would be a maximum of 3 individuals, plus the judge, should have their camera and microphones live. Everyone else must keep their cameras off and their microphones muted. Timekeepers may come on as necessary to alert their teams at the appropriate times. That may be either showing on the camera with your time sheet or your time card, or you can also put it in the chat for everyone. If you're not one of these performing attorneys or witnesses or timekeepers, I'm going to ask that you exit now. I don't see that we have anyone else other than the court and our scorekeepers. So I think we're set there. And if you have family members who have not tuned in yet, they can tune in on the YouTube live stream to watch the mock trial rather than being in on the meeting here. So it appears that we are now ready to be in session. I will turn the courtroom over to Judge Ellison.
Right. Good afternoon, everyone. And I am going to ask for a clarification on the participants first. I did not here, or I did not write down, defense attorney 1, who will be cross-examining the first prosecution witness.
That would be me, Haley Erickson, and I'll be crossing Alex Cifuentes.
Thank you very much, Ms. Erickson. All right, the court will call the case to order. This is the prosecution versus Avery Becker. And we are here today for a trial. To the prosecution, Ms. Martin, is the prosecution prepared to proceed to trial?
Yes, Your Honor.
All right. And to the defense, Ms. Rowe, is the defense prepared to proceed to trial?
Yes, Your Honor.
All right. Let me first go ahead and swear folks in. To all of the team members, please raise your right hands. Team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? And I see most people nodding. Thank you. All right. And to the witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained within the case problem, and that you will follow the rules and procedures of the mock trial competition? And I do see everybody nodding as well. Scoring panelists, I will ask you to raise your right hands as well. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? And I do see Mr. Ringenberg, and Ms. Lilly. All right. And Ms. Ross, I'm going to presume that you also are nodding. All right, there we go. Thank you very much. All right, for the prosecution, Ms. Martin, your opening statement.
Thank you, Your Honor. Your Honor, members of the jury, the defendant, Avery Becker, wanted to get back at Mackenzie Brackman if it was the last thing that they did. We are gathered here today because Mackenzie Brackman was murdered on March 6 of 2020. On that day, Mr. Brackman's Ring doorbell system recorded a masked intruder entering the back of his home, and the following morning he was found stabbed in the back with a large kitchen knife. Mr. Brackman was a local criminal defense lawyer, but was also the head coach of the Colorado High School mock trial team. Just days before Mr. Brackman's murder, the defendant, who was a senior on the CHS mock trial team, was angry with Mr. Brackman, for they had been kicked off the team after vandalizing Mr. Brackman's car. The defendant was so angry after the incident, angry enough to say, "I would get back at him if it was the last thing that I did. If he's still upset about his car, just wait until he sees what I do to his house. I'm going to wait until he's at work, break in, and trash it." Now, anyone can tell you that Mr. Brackman and the defendant had a rough relationship, but it went beyond the typical feud. Now, the defense wants a riveting explanation for what happened to Mr. Brackman, not the simple answer of what did. See, the facts in this case are straightforward, ladies and gentlemen, despite what the defense may tell you. Today, the prosecution will call 3 witnesses, Alex Cifuentes, Kyle Kuzak, and Detective Jordan Markowitz, who will attest to the facts in this case today. First, we intend to call Alex Cifuentes, a fellow mock trial student, who will testify to the repetitive history of aggression the defendant exhibited. Mr. Cifuentes will talk about his firsthand observations of the unusual feud the defendant had with Mr. Brackman, and confirm that the defendant sent him messages saying, "If Mr. Brackman is still upset about his car, just wait until he sees what I do to his house. I'm going to wait until he's at work, break in, and trash it." These messages were sent to Mr. Cifuentes just days before Mr. Brackman's murder. You will next hear from Kyle Kuzak, a Colorado Bureau of Investigation certified crime scene reconstruction investigator, who will confirm that Mr. Brackman's death was a result of a burglary gone wrong when Mr. Brackman confronted an intruder breaking into his home. Mr. Kuzak will explain how he reached this conclusion using detailed reconstruction analysis. Last, you'll hear from Detective Jordan Markowitz, the homicide detective who investigated Mr. Brackman's death. Detective Markowitz will explain how she followed the evidence to the best conclusion and that Mr. Brackman's death was the result of a burglary gone wrong. Detective Markowitz will also explain how her investigation went in the unlikely direction towards the CHS mock trial team and the defendant, where upon further investigation, she obtained text messages between Alex Cifuentes and the defendant, where the defendant clearly outlined a plan to wait until Mr. Brackman was at work, break into his home, and trash it. Detective Markowitz also obtained cell tower data from the defendant's phone. This data reveals that the defendant's phone traveled from their home to Mr. Brackman's home, taking the most logical route, placing their phone in the vicinity of Mr. Brackman's home at the time of his murder. In this case, the prosecution must prove beyond a reasonable doubt that the defendant, while committing second-degree burglary, committed a felony murder in the first degree. Under Colorado law, second-degree burglary is when a person either knowingly enters or unlawfully breaks into a dwelling with the intent to commit criminal mischief against another person or property. Felony murder is when, in the course of committing second-degree burglary, an individual attempts to commit or commits the death of another person. In this case, the evidence will prove beyond a reasonable doubt that the defendant, while committing second-degree burglary, committed a felony murder in the first degree. Though the defense may present an alternative theory, we ask you to remember to follow the evidence. The defense's case is backed by the assumption that the defendant's alibi is sound, despite the fact that the only person who can confirm it is the defendant's best friend, Taylor Perkins, who is someone who is willing to do anything for their best friend. The defendant claims that their threats were made in the heat of the moment and they would never act upon them, but the evidence and testimony that will be heard today will prove that they did. See, the defendant was someone who had a history of aggression and an unusual feud with Mr. Brackman. They were angry for being kicked off the team, and the facts will show that they acted upon this anger once again. For they would get back at Mr. Brackman if it was the last thing that they did. Members of the jury, Your Honor, we implore you to follow the evidence to the best straightforward conclusion. We urge you to return a verdict of guilty. Thank you.
Thank you, Ms. Martin. Ms. Rowe, the defense opening statement.
Yes, can I just begin? All right. Ladies and gentlemen of the jury, we are here today to prove the innocence of a high school student who has been falsely accused of a murder that they did not commit. We present you with a story with anger, deceit, and lies, one that casts Avery Becker as a villain to hide us from the real truths of this case. Ladies and gentlemen, we are trapped in a spider's web, one with many winding strings. While the proponent will set this out as a straightforward case with one clear and definitive story, you will see that there are many ways that it could have gone. Our story begins with the members of the CHS mock trial team and their rocky relationship with their coach, Mackenzie Brackman, who belittled and steamrolled the members on their team. Overall, you will see how they took the opportunity to frame the young Avery Becker for a crime that she did not commit. We will neither conceal nor overlook any evidence, and we will present you with the facts as they are and allow you to come to the appropriate conclusions yourself. The evidence will show that Avery Becker did not murder Mackenzie Brackman and that she was away from the scene of the crime and that her alibi checks out. It will show the many ways that the murder could have been committed and that there is no way to know without a reasonable doubt who committed the crime. First, you will hear from Avery Becker, a motivated high school student who has been doing mock trial for many years, and that she was looking for her phone with her friend Taylor Perkins, and that there was no feasible way for her to have committed the crime. And how there were many other people with more motive than her to kill Coach Brackman. Then you will listen to Taylor, another member of the mock trial team who's a close friend of Avery Becker's. You will hear from Avery and Taylor that they were so close that they felt no need to keep anything from one another, and that Taylor's testimony is completely forthcoming. You will hear that Avery, after accidentally marking Brackman's car with a permanent marker, felt horrible about what she did and did everything she could to rectify it. And from that, you will see that she had no ability to commit such a crime guilt-free, and that she would have never murdered him in the first place thanks to her mock trial knowledge on court systems and consequences. Finally, you will gain information from Blake Van Owen, the private civilian investigator who inspected the crime. You will hear from him the inaccuracies of the detective's finding and how his testimony describes how the detectives followed the easy conclusions rather than closely looking at the facts, and that they failed to investigate the full story. You will also have the opportunity to hear from the proponent, who will try to convince the jury that all evidence clearly shows that Avery Becker was at the scene of the crime and committed the murder. They will try to convince you that Avery Becker had motive and means to kill Coach Brackman, and that she was the only one that could have reasonably done it. In our defense, you will see that Avery Becker had none of these things, neither motive nor accessibility, and that she was in no way the only suspect that could have done it. You will receive a testimony from Kyle Kuzak, a civilian contractor, who claims to have put together a timeline and will condemn Avery for the murder. You will see that he was not a police officer, that he lost evidence, ignored facts, and jumped to conclusions. Alex Cifuentes will give a testimony as a member of the mock trial team who continually claims that he and Avery Becker were friends despite her testimony that they were not. You will notice that Alex and Avery were not, in fact, friends, whether they were particularly hostile or not, and that Avery would never confide in Alex. You will also see that Alex manipulated the truth and falsified evidence against Avery Becker. You will also hear from Detective Jordan Markowitz, an officer who, after examining the crime scene, will testify that Avery Becker was the one that killed Coach Brackman. The phone signals would point that Becker was going to the scene of the crime, even though she testified against having her phone at all during the time of the crime. Evidence was destroyed, and upon Alex Cifuentes not having his phone at the interrogation, allowed him to continue without it, and had no way of knowing whether the screenshots given to him were legitimate or faked. He followed the easy and obvious path without traveling with the facts to discover the real truths of this case. Ladies and gentlemen of the jury, if you are not convinced by the evidence that Becker committed the crime beyond a reasonable doubt, and that she might have been away from the crime, that she might not have had adequate motive to commit the crime, then you must acquit her. We do not have to show that these conditions were undoubtedly true, rather that it is beyond a reasonable doubt, and that there is greater than a 50% chance that any one of these claims are true. In this trial, the evidence will show you that this is the case. If you find it more likely than not that any of these conditions are true, then you must find my client innocent. Thank you.
Thank you, Ms. Rowe. Ms. Martin, I believe you are calling the prosecution's first witness.
Yes, Your Honor. The prosecution would like to call Alex Cifuentes to the stand.
All right. Mr. Cifuentes has turned his video feed on. Ms. Martin, you may begin your direct examination.
Thank you, Your Honor. Good afternoon, Mr. Cifuentes. Can you please spell your name and spell the last for the record?
Of course, Alex Cifuentes, S-to-the-I-F-U-E-N-T-E-S.
Now, Mr. Cifuentes, how old are you?
I am 18 and I'm currently a senior at Colorado High School.
And how did you know the late Mackenzie Brackman?
Mr. Brackman was our amazing Colorado High School mock trial coach.
And how did you know Miss Becker?
Avery Becker was a fellow teammate of mine on the mock trial team at the high school.
During your time on the high school mock trial team, were you and Miss Becker ever rivals?
Of course not. Avery and I have always been really good friends, basically good best friends within the team, equally skilled team members who push each other to be better. We obviously spent all 4 years of mock trial together doing pretty well.
Did you and Miss Becker spend a lot of time together?
Of course we did. You know, mock trial is such a time-consuming activity. We spent countless hours together working on practices and tournaments.
Moving on towards the dynamics of the team, in your perception, did Miss Becker and Mr. Brackman get along?
Oh no, Avery was constantly late to practice and just had no respect for Mr. Brackman. Mr. Brackman would often confront Avery about her complete lackadaisical attitude towards the team. And at times, Avery, would refuse to do as Mr. Brackman had wished. When Mr. Brackman called her out on her actions, she would get really infuriated.
Objection, Your Honor. Hearsay. Just to the last section when he was testifying towards Avery Becker's personal feelings.
All right. And Ms. Martin, any response as to that last statement made by Mr. Cifuentes?
Yes, Your Honor. This question is asking merely for the witness's present sense impression, which is under Rule 803.1. And it's merely asking for a statement for his immediate perception of the events over a continuous time on the mock trial team.
Any further record to make, Ms. Erickson?
No, Your Honor.
I'm going to overrule the objection as to Mr. Cifuentes' observations of the reaction. You may continue.
Thank you, Your Honor. During your time on the team, Mr. Cifuentes, was Miss Becker ever demoted from the A team?
Yeah, she was. The relationship met a boiling point. When Avery arrived to practice, of course, it's really late for I don't know how many times then. And Mr. Brackman then demoted her to the B team.
And did Avery ever return to the A team?
She did. Somehow she convinced Taylor Perkins to quit the team and forced Mr. Brackman to bring her back onto the A team.
After this, was there any other major disputes between Ms. Becker and Mr. Brackman?
There was indeed. At the practice after regionals, Mr. Brackman had told Avery that while she did win those awards at competition, best attorney and closing argument or whatever, a good lawyer would prepare for court and present the best work. Mr. Brackman's comments, of course, infuriated Avery, and I saw her.
Objection, Your Honor, to speculation again.
Ms. Martin?
Yes, Your Honor. The witness is merely again testifying to his sense perception of the immediate aftermath and during this altercation between Mr. Brackman and the defendant. And it is merely just a observation of what occurred.
At this time, I am going to sustain the objection on speculation grounds. Mr. Cifuentes was testifying that Mr. Becker was infuriated. He can testify to what actions he observed that might have caused him to think that, but he cannot testify to what Mr. Becker was feeling. So I will sustain the objection. Ms. Martin?
Mr. Cifuentes, I'll re-ask the question. How did you perceive Avery's behavior during the dispute?
Well, after their confrontation, Avery stormed out of the door, slammed the door, and left, in my perception, of complete anger.
And what happened after their dispute?
Well, as Avery was storming out of campus, they did the unthinkable and vandalized Mr. Brackman's prized Porsche 86, I think, by writing "Worst Attorney Award" right across the hood in permanent marker.
And did you witness Ms. Becker taking the marker that was used to vandalize Mr. Brackman's car?
Of course I did. I was right there.
Had Ms. Becker been standing near a whiteboard?
Not at all. The marker was not on the dry erase board. It was a permanent marker on the easel of paper that we write down our trial ideas and such on. Avery couldn't have think that it was not a permanent marker.
Objection, Your Honor, to speculation again.
Ms. Martin?
I have no response, Your Honor.
Okay, I'm going to sustain the objection. That final remark will be stricken of Mr. Cifuentes. Ms. Martin, you're questioning?
Yeah. After the incident, was Ms. Becker permanently removed from the team?
Avery was. Mr. Brackman was caring enough not to press charges against Avery.
And after the vandalization of Mr. Brackman's car, did Ms. Becker ever try and ask you to convince Mr. Brackman to let them back on the team?
Objection, Your Honor, to hearsay.
Ms. Martin, response?
Your Honor, this question is merely asking for whether or not the witness received text messages from the defendant, and they are going to testify to whether or not they received these text messages in which after the defendant was removed from the team.
Okay. The question that was asked was whether or not Mr. Becker had asked to get back on the team. And so I am going to sustain as to hearsay. You could certainly ask additional questions on your continued direct or on redirect if you wish.
Did you ever attempt to try and help Avery get back on the team in any way?
Avery had sent me multiple text messages asking me to speak to Mr. Brackman on their behalf and try and convince him to let her back on the team.
And did this work?
No, Mr. Brackman was not really interested in bringing back Avery after all that she had done. I don't think it was just singularly the vandalization, but everything leading up to that point that Avery had done.
Now moving on, Mr. Cifuentes, a few weeks after Mr. Brackman was murdered, were you ever contacted by a police detective?
I was. I ended up telling the detective about the messages that Avery had sent to me about a plan to break into Mr. Brackman's house. I didn't want to rat Avery out, of course, since it was just a text message. I didn't know Avery's true intentions through that, but I certainly wasn't going to lie about anything.
Were you also ever contacted by a private investigator?
I was. A couple of weeks ago, one came by and, they tried their best to try and get me to say something that they could use against me during trial, but I know that they weren't really here for the truth of the matter, and so I didn't want to talk.
Your Honor, to speculation.
Okay. Ms. Martin? Response?
Your Honor, this is again merely, or the question was attempting to figure out whether or not the witness was contacted by a private investigator. However, the witness did testify to some speculation. So I
am going to sustain the objection as to what the investigator was purporting to do or what the investigator's intent was. I will certainly allow Mr. Cifuentes' statement that he was contacted by the investigator a couple of weeks ago to stand.
Thank you, Your Honor. During your meeting with the private investigator, did you learn that you were accused of anything?
I did. She was accusing me of stealing Avery's phone on the night that I was right with her at the Fry Shack, and supposedly giving it to some kid named Blair Rollins. She also accused me of the text that Avery had sent me, that I somehow faked them. I don't even know how I'm able to do that.
Did you know Blair Rawlings?
I mean, we all went to school together. Same with Avery and Taylor, every student on the mock trial team. I know of Blair Rollins. I don't know him at all personally.
Would you have stolen Miss Becker's phone?
Of course not. I wouldn't have stolen anyone's phone, certainly not Avery's phone, and most definitely not Avery's phone for some kid named Blair Rollins. I even further wouldn't have done anything to put Mr. Backman in danger.
Coming back to when you were contacted by the police, were you ever requested to conduct an interview at the police station?
I was.
And did you bring your phone that had the text messages from Avery?
I didn't. When I was leaving the house, my phone is really old. It's pretty much a brick at that point, and it'd be constantly plugged in to be usable. And since I know I had those text messages from Avery, I wanted it to be on a full charge. But when my dad yelled at me to leave, I completely forgot that he was still charging.
Did you offer to bring the phone after the interview?
I did. I offered whatever I could to the detective, and they said it was totally fine for me to send screenshots of the text instead. There's no complication with that.
Your Honor, let the record show that I'm directing opposing counsel to what has been previously marked and provided as Exhibit 14. Permission to direct the witness.
You may do so.
Thank you. Mr. Cifuentes, can you please direct your attention to what has been previously marked and provided as Exhibit 14? And may you please identify it?
I can. These are the exact messages that Avery had sent to me.
Have you ever received text messages from Avery before?
Of course, we talked together quite a lot regarding mock trial and things outside of that.
Are these the messages that you received after she was kicked off the team?
They are indeed.
And these messages came directly from your phone?
Yeah, I only have one phone. Avery sent those to me through that.
And were these text messages altered in any shape or form?
Of course not. They're just screenshots of them. I don't know how I would alter them.
Is this a true and accurate representation of the text messages the defendant sent you?
Of course they are.
Your Honor, I would like to ask to move Exhibit 14 into evidence.
Okay. Ms. Erickson, any objection?
No objection, Your Honor.
All right, the court will receive Exhibit 14 into evidence. It is a 2-page exhibit. Go ahead, Ms. Martin.
Thank you, Your Honor. Assuming that the jurors and everyone in this courtroom has already been previously provided these exhibits, can I constructively publish and allow the jurors to view it for a couple seconds?
You may.
Thank you. All right, Mr. Cifuentes, continuing on, what was the specific text message you received from Ms. Becker after they were removed from the team permanently?
Avery had sent me a text message saying, if Mr. Brackman thinks he was upset about what I did to his car, wait until I see what I do to his house.
Thank you, Your Honor. No further questions.
Ms. Erickson, cross-examination of Mr. Cifuentes.
Thank you, Your Honor. So, Mr. Cifuentes, just to clarify for the jury, you believe that Avery Becker murdered Mackenzie Brackman?
Of course I did.
Yet,
of course I did, yes.
Yet you and Avery are good friends?
I'm good friends with lots of people. What's not to love about people? I mean, they're amazing. I think I'm friends with a lot of people. Friends can mean a lot of things. Avery and I obviously spend a lot of time together on mock trial and in school, we got to know each other pretty well. We spent a lot of time together within the Fry Shack and mock trial competition.
That will suffice,
Yeah,
Mr. Cifuentes. Thank you. Did you like Avery very much?
Yeah, I mean, we certainly had our differences, but we got together pretty well. Obviously, we spent the 4 years of mock trial together. We knew each other pretty well. Yeah, we got together fairly well.
And
of course,
moving on, Avery received frequent awards as a member of your mock trial team, did she not?
Yeah, Avery, yeah, she did.
And giving the ground to you, finally, how did this make you feel?
Well, I was obviously proud of Avery's accomplishments. I didn't think that they, particularly this last regional competition, that Avery had presented the proper foundation and work for those achievements. Obviously did. And, you know, the judgments made during competition to provide Avery with those awards are across many people. And obviously I'm not one to dictate whether or not Avery should have earned those, but yeah, she did earn those awards.
And so you are of the opinion that she deserved the award she was given?
I mean, she obviously, I didn't think she was very prepared for competition. So not
yeah, a
correctly.
yes or no will suffice, Mr. Cifuentes. Do you think that she deserved the awards, in your opinion?
In my opinion, I don't really think so, but that doesn't mean
Thank you.
anything really. Of course.
And along those lines, you maybe were unhappy that she received those awards?
Unhappy, I mean, it doesn't really matter. It's just mock trial. I mean, Avery, I was proud of Avery and her accomplishments, but
yeah,
I mean,
Mr.
I was
Cifuentes,
excited for myself.
Objection, Your Honor.
Ms. Martin?
I would like to ask counsel to please allow the witness to finish answering the questions before interrupting.
And Ms. Erickson is cross-examining the witness, so he is an adverse witness. She is able to, if she's gotten her answer, she is able to ask him to allow her to move on to the next question. So I'm going to overrule that objection.
Thank you, Your Honor. And so, just to clarify, yes or no will suffice. Did you like that Avery received the awards?
No.
And along those lines, did you were you equally as unhappy when Avery received most recently the Best Attorney Award?
Wasn't that what you just asked me? If I was happy that Avery received those awards?
I was asking towards this one specific award, but.
I mean, it's pretty much the same thing, so that I have the same answer.
Okay, and that answer was, just to clarify?
No.
Thank you. And so to keep the narrative, after she received this award further on, she had written on Mr. Brackman's car, correct?
Right across the hood in permanent marker. Had to have seen it yourself.
Now, you're a mock trial student. Is there any clear evidence that proves Avery knew said marker was permanent?
There is complete evidence. I don't know who would write on a whiteboard with permanent marker. I don't know who would write on an easel of paper with a dry erase marker. Avery obviously grabbed the marker from the easel of paper they write our ideas from trial on. Obviously, it's a permanent marker on that easel of paper. Avery took it and stormed out the door and then obviously wrote across his hood.
Well, but Mr. Cifuentes, is there any evidence as to Avery's knowledge of it being permanent, not whether or not it was?
I don't know what Avery thinks. I don't know how she could have not thought that it was not a permanent marker, but that's up to Avery, I guess, to determine really what she was thinking in the moment. But I don't see how anyone would think that a permanent marker would not be written on a whiteboard.
Well, in any case, following this, Avery was dismissed from the mock trial team, correct?
Yes, Mr. Backman had enough of Avery's actions.
And this kept your team from going to the state competition?
Yeah, I knew that our team would be better off without Avery, but we did need Avery's participation to compete in the state tournament.
And along those lines, you knew that the team was, you just said you knew the team would be better off. Would you say would you say that you personally would be better off without Avery on the team?
I mean, sure. It's just a team. Avery, her participation was, it was good on the team, and obviously we were pretty equally skilled. Obviously, if Avery wasn't on the team, that would just statistically be more of a.
Yes or no will suffice, Mr. Cifuentes.
To what question? Could you clarify so that I can simply answer yes or no?
Yes, I will restate it. Were you personally better off with Avery not on the team?
You could say so, yes.
And you would receive a larger role in her absence, would you not?
I can't predict the future.
But you were excited for a larger role.
I definitely, statistically, if Avery wasn't there, there would be more of a chance for me to take on a larger role. So sure.
Thank you. And to move to something else, shortly after Mackenzie Brackman was unfortunately found dead later on. Yes.
Yeah, unfortunately, Mr. Brackman had died. Such a tragic event.
And later, you were called for an interview, correct?
Yes, I was called down to the police station to give an interview with a detective.
And this interview was because of a text conversation you had with Avery about helping her get back on the mock trial team?
It wasn't because of that, but that was one of the pieces of evidence that was brought up in my investigation with the detective.
And you did not bring your phone to the first interview, correct?
I explained this earlier. No, the only thing that I was really using it for at the time, it had those pictures, and I knew that. So I left it in charging so it'd be at a full charge so I could take it down to the station and still have it fully charged to present to the detective.
And in
in
consequence, you simply sent screenshots of your conversation to the detective.
As requested by the detective, and they said it was totally fine and there's no complication regarding that.
But you never showed the detective or anyone the actual conversation on the actual phone.
I sent over the actual conversation from my phone with the screenshots to the detective. So, I pretty much did.
But the phone itself was never seen by anybody else?
No, it is currently sitting probably 10 feet under garbage in some landfill.
And yes or no, you do not have this phone any longer, as you just said.
No, I don't.
And to finish my questions, do you believe Avery Becker, your good friend of you stated and teammate, to have killed your coach, Mackenzie Brackman?
Of course I do. It couldn't have been anyone else. Avery obviously had quite the relationship with Mr. Brackman, as we can see. The text messages Avery sent me clearly show that Avery was planning to do something to Mr. Brackman. So obviously, I think.
Needed a yes or no, Mr. Cifuentes. You believe that your friends did kill somebody?
Yes, I believe Avery killed Mr. Brackman.
No further questions, Your Honor.
Right. Thank you, Ms. Erickson. Ms. Martin, any redirect?
Yes, Your Honor. Now, Mr. Cifuentes, were you and Miss Becker ever rivals when you were on the mock trial team?
Like I said earlier, of course not. Avery and I spent 4 years together pretty well. We got along together pretty well. We definitely had our differences, but no, we were good friends.
Did your differences ever get in the way of your friendship?
Certainly not. At times there was slight confrontations between our thoughts, but we never had any serious complications with our relationship.
And Mr. Cifuentes, would you have ever wanted to do anything that put Mr. Brackman in any harm?
Mr. Brackman, of course not. Rest his soul. What a great coach. Miss him dearly.
Thank you, Your Honor. No further questions.
And any recross, Ms. Erickson, based on that redirect?
No, Your Honor.
All right. May this witness be excused?
Yes, Your Honor.
All right. Ms. Jupiter, I believe you are counsel for the prosecution at this time. Would you call the prosecution's next witness?
Yes, Your Honor. The prosecution would like to call Kyle Kuzak to the stand. And may I also request a time check?
Certainly. To the timekeeper for Team Minecraft, would you please give us an update? And that
Wait,
was
on which team's time?
on Minecraft. So Ms. Fabian, I believe, is the timekeeper.
Yes, I had about 15 minutes.
Thank you.
Go ahead, Ms. Jupiter.
Thank you, Your Honor. Mr. Kuzak, can you please state your name and spell your last for the record?
Yes, of course. My name is Kyle Cusack, last name being spelled K-U-Z-A-K.
And what is your current job, Mr. Kuzak?
Well, I currently work alongside the Denver Police Department as a CSR, or Crime Scene Reconstruction Investigator.
Do you have any certifications for your work?
Yes, as a matter of fact, I do. Seeing my methods as tried and true, the Colorado Bureau of Investigation has decided to certify me as a CSR.
And Mr. Kuzak, what types of cases have you previously investigated?
Well, I've investigated plenty of complex crime scenes, some of which ranging from home invasions, burglaries, and other property crimes, homicides, to accidents, domestic violence, and even armed robberies, to name a few.
Oh my. Mr. Kuzak, how long have you been in this field?
I have been working as a crime scene reconstructionist for over 19 years at this point.
Thank you. Your Honor, considering Mr. Kuzak's state certification and lengthy experience in a variety of different cases, I'd like to certify him as an expert in crime scene reconstruction.
And I believe this is Mr. Cameron's witness. Any objection from the defense?
No objection, Your Honor.
All right, thank you. I will allow Mr. Cusack to testify as an expert in the field of crime scene reconstruction. Ms. Jupiter, you may resume your questioning.
Thank you. Mr. Kuzak, how did your involvement with this case begin?
Well, my involvement with this case began when I personally visited the crime scene. It is in my opinion that when you visit a crime scene, it enhances your perspective and gives you insights that might otherwise go unnoticed. Following or thereafter, I would review all of the police reports in this case, the photographs from the crime scene, as well as the 4 Ring security camera videos.
And Mr. Kuzak, when you visited the crime scene, what pieces of physical evidence stood out to you?
Well, there was fortunately a lot of physical evidence that stood out to me. There were scuff marks near the back sliding glass door, a broken plate on the floor, an open knife drawer, a knife that was missing from the knife block, blood spatters that would eventually lead to the victim's body.
Thank you. I'm going to ask you a bit about each of these pieces of evidence and how they contributed to your report.
Of course.
Your Honor, let the record show that I'm directing the defense counsel to what has previously been marked as Exhibit 18. Permission to direct the witness.
You certainly may.
Thank you, Your Honor. Mr. Kuzak, do you have this photograph in front of you?
Yes, I do.
And do you recognize this photograph?
Yes.
Is this one of the same photographs you used to create your report?
Yes, it was.
And would you say it's a fair and accurate representation of the crime scene you saw?
Indeed, it is.
Your Honor, I ask that this exhibit be moved into evidence.
Mr. Cameron, any objection?
No objection, Your Honor.
All right. The court will receive Exhibit 18, and Ms. Jupiter, you may publish to the jury if you wish.
Thank you, Your Honor. Permission to publish this constructively.
Certainly.
Thank you, Your Honor. Mr. Kuzak, what is this photograph?
This is a photograph taken of the scuff marks that were found near the back sliding glass door.
What did you conclude from this photograph?
Well, from these evidence, I could conclude that this is where the scuffle between the intruder and the perpetrator, the intruder and the victim began.
Moving on, you mentioned a broken plate. What did you conclude from this piece of physical evidence?
Well, from this piece of evidence, I concluded that the scuffle between the perpetrator and the victim would move from the back sliding glass door to the kitchen table, where it may have even increased in intensity, knocking the plate off the table.
What did you conclude about the open drawer and the missing knife?
Well, After being notified to the presence of the intruder, the victim needed to arm themselves. They chose to first look through the knife drawer, but later decided to pick a knife from the knife block.
And Mr. Kuzak, what was the ultimate outcome of this altercation?
Well, the ultimate outcome of the altercation was the intruder entered through the back sliding glass door. They would move to the kitchen table where the scuffle would increase in intensity, knocking the plate off the table. Thereafter, the knife would be wrestled from the victim's grasp and the victim would be stabbed in the back, leading to the front door.
Thank you, Mr. Kuzak. Based on your perception, what type of crime occurred at this scene?
While I cannot say whether or not the intruder was entering with the intent to murder, I can say the outcome was definitely a felony murder.
And Mr. Kuzak, are you aware of the theory that Professor Van Owen deduced from the same crime scene?
Yes, I am.
Are there any discrepancies between his report and your own?
Yes, there are actually a lot of discrepancies. The professor's theory fails to state why there are scuff marks near the back sliding glass door, why there was a broken plate on the floor, or even how the perpetrator had the time to rifle through their own knife drawer. It fails to explain why they would have picked the knife out of the knife block instead. And finally, my biggest discrepancy with his theory is that, well, he never even visited the crime scene, so they never even visited the crime scene, so they don't have the same perception that I do.
And lastly, was your work peer-reviewed after you finished your report?
Yes, my work is always peer-reviewed as the fifth step in my process to make sure it is both logical and sound of mind.
Thank you, Mr. Kuzak, and thank you, Your Honor. I have no further questions.
All right. At this time, cross-examination, Mr. Cameron.
Yes, Your Honor. Good afternoon, Mr. Kuzak.
Good afternoon.
So you say in your statement that you are not actually a police officer, is that correct?
That is correct. I actually find myself more wanting to work alongside the Denver Police Department, not as a police investigator.
Okay, thank you. And as you said in your statement again, a lot of the digital evidence was lost. Is that correct?
Well, the evidence wasn't necessarily lost. Sometime after my investigation had already been completed, the files had corrupted, but that was of no consequence to my analysis.
Okay, and you had access to the information before it was lost?
Yes, I did. As I was working alongside the
Just a
department,
yes or no answer will be fine, Mr. Kuzak.
Yes, I had plenty of time to analyze it.
And you were trusted with the information?
Well, while I was trusted with the information, it was sent to me by the police department.
But you couldn't stop it from being corrupted?
I don't see how anybody could stop any files from getting corrupted.
It also states in your testimony that you were not able to recreate the scene with full accuracy?
Well, it's impossible to recreate a scene with full accuracy as...
Again, I apologize for the redundancy, but just a yes or no answer will be just fine.
Well, of course, I wasn't able to place all of the physical evidence in the case, but I can say what most likely did occur.
So information was allowed to be corrupted by whomever, and you were not able to create the crime scene with full accuracy.
Well, once again, I will say that this occurred after I'd already analyzed it, but as a CSR, you always want more physical evidence than the crime scene allows, but I can still say I'm fairly confident in my analysis.
So is there any way to really know if your findings are absolutely correct based on the loss of information as well as your inability to recreate the scene with full accuracy?
Fortunately for me, the other investigators in the crime department can tell you this is all the evidence was there, and my lengthy process ensures that it is accurate. So.
Thank you, Mr. Kuzak. No further questions.
Ms. Jupiter, any redirect?
Yes, please, Your Honor, briefly. Mr. Kuzak, did you have access to the now corrupted photographs while you were creating your report?
Of course, I had access to the photographs sent to me by the department for the entirety of my analysis.
Thank you. And were you able to personally observe the contents of these photographs while you visited the crime scene?
As a matter of fact, yes. While at the crime scene, I was able to analyze every piece of evidence as I was there for analyzing the evidence.
Thank you, Your Honor, and thank you, Mr. Kuzak. I have no further questions.
Okay. Mr. Cameron, any recross based on that redirect?
Yes, Your Honor, briefly. So, Mr. Kuzak, you say that you, in fact, had access to the files before they were corrupted, and therefore were able to incorporate them into your findings?
While I did have access, this wasn't the only basis for my final conclusion, but I guess, yes, I did.
However, we do not have access to the files now, so there is, in fact, no way to prove that your findings based on this evidence is correct.
Well, fortunately for you, everything I have testified to today has been evidence that is still photographs
Just
of.
a yes or no answer will be just fine. Thank you, Mr. Kuzak. And no further questions, Your Honor.
All right. May this witness be excused, Ms. Jupiter?
Yes, Your Honor.
All right. I believe prosecution counsel for witness number 3 is Ms. Faulkner.
Yes, Your Honor. I'd like to call Detective Jordan Markowitz to the stand, please.
All right. And Detective Markowitz is there. All right, you may begin your direct.
Thank you, Your Honor. Can you please state your name and spell your last for the record?
Yes, Jordan Markowitz, Markowitz.
And what is your profession, Detective Markowitz?
I'm a homicide detective with the Denver Police Department.
How long have you been with the DPD?
13 years.
How long have you worked as a detective there?
I apologize. I think I missed the last question.
Oh, how long have you worked as a detective for the Denver Police Department?
7 years.
Have you received any special training to assist you in your duties as a homicide detective?
Yes, I received and passed a course by the American Academy of Law Enforcement on cell phone technology and forensic data recovery.
And what did you learn through this training, Detective Markowitz?
This training taught me how to interpret and download cell phone data records, as well as information from cell phones, and interpret using certain analysis technologies such as Cellebrite.
Excuse me, Detective. Do you frequently use this special training in the course of your work as a homicide detective?
Almost constantly. I've downloaded hundreds of, information from phones, and I have used a cell phone tower.
And Detective Markowitz, I think we had a bit of a technological glitch there. I think you froze up just a moment. So you said, I have used cell phone tower, and then you cut off for a little bit. If you could restate that.
Cell phone tower data in over 50 cases.
Thank you very much, Detective Markowitz. Your Honor, I'd ask you to qualify Detective Jordan Markowitz as an expert in the areas of forensic investigation and cell phone forensics under Rule 702, based on her abundant experience, skill, and knowledge in those fields. Rule 702 states that a witness may be qualified as an expert if they have knowledge, skill, experience, training, or education that enables them to testify to opinions. Detective Markowitz has extensive experience in forensic investigation of homicide cases, and she has passed a certification course in obtaining cell phone evidence in forensic investigations.
And Ms. Rowe, I believe you are cross-examining the detective. Do you have any objection to her testifying as an expert in those fields?
Objections, Your Honor.
All right. I will permit Detective Markowitz to testify as an expert in the areas of cell phone technology and forensic investigation and data recovery. You may continue, Ms. Faulkner.
Thank you very much, Your Honor. Would you describe for the jury how you became involved in this case, Detective Markowitz?
Yes, I responded after paramedics were called to the scene of Mackenzie Brackman's murder at around 14:20 hours.
And when you arrived at the scene, did you immediately observe Mr. Brackman's wound?
Yes.
Were you able to recover any security footage from Mr. Brackman's home?
Yes, Mr. Brackman had a Ring doorbell, which allowed me to download security footage of an intruder entering the home wearing a hoodie, a Halloween mask, and gloves.
Were you able to recover any other material from Brackman's cell phone?
Yes, I was able to download a fair amount of his texts and emails.
Did you observe any significant patterns in the messages that you investigated?
Yes, he seemed highly involved in something called mock trial. It appeared he was a coach for a local team.
And did you further investigate this affiliation?
Yes, I did. I contacted Colorado High School to get contact information for some students.
Which student did you contact first, Detective?
I was able to contact Alex Cifuentes, who told me that he had received to trash Brackman's house.
And Detective Markowitz, you glitched out a little bit again. He told you he had received.
He had received several text messages from another student who had planned to trash Coach Brackman's house.
Thank you.
Thank you, Detective. And did you interview Cifuentes after getting this information?
Yes, we were able to conduct a full police interview down at the station.
What did you learn from this interview?
I learned that Alex had received several texts from Avery Becker after they were kicked off the mock trial team.
And did Cifuentes have his phone at the station?
No, he had forgotten it, so I just got him to send screenshots later on.
Thank you, Detective. After your investigation of the Cifuentes lead, did you contact Avery Becker?
I attempted to contact Avery Becker, but I was informed by their lawyer that I wasn't allowed to speak with them.
Despite this, were you able to obtain a search warrant for Avery Becker's cell phone?
I was able to obtain a search warrant for their phone, but I was informed it was lost around March 5th.
Were you able to obtain any cell data at all from Avery Becker?
Yes, I was able to obtain call detail records.
Detective, would you briefly explain what a call detail record is for the jury?
Yes, a call detail record, or a CDR, is just a recording of the communications between a phone and a cell tower.
And what types of information can be obtained through a CDR?
Things like the time and date of a call, the duration of this call, whether or not it was answered, and what antenna it responded to on the cell phone tower.
Under normal circumstances, do cell phones connect with the nearest cell tower?
Yes.
So moving back to the specifics of this particular case, did you notice any important points while you were reviewing Avery Becker's CDR data?
Yes, around the time of Mackenzie Brackman's murder, there were several calls placed to Avery Becker by another student, Taylor Perkins.
And based on the duration of those interactions, were any of those phone calls answered?
No.
Your Honor, I'd like to direct your attention, the attention of the opposing counsel and the witness, to the diagram previously marked as Exhibit 16.
Okay.
Detective Markowitz, would you describe the contents of this exhibit for the jury?
Yes, this is a diagram I made in the course of my investigation that demonstrates the cell phone, the CDR of Becker's phone.
Is this exhibit a fair and accurate representation of the diagram that you created?
Yes.
Do professionals in your field regularly create diagrams to help them in the course of their duties?
Yes.
Your Honor, I'd like to ask you to admit Exhibit 16 into evidence.
And Ms. Rowe, any objection?
Objections, Your Honor.
Court finding no objection will permit Exhibit 16 to be admitted. And Ms. Faulkner, if you would like to publish to the jury constructively, you may do so.
That would be wonderful. Thank you very much. Ms. Markowitz, can you describe what this diagram signifies for the jury?
Yes, this demonstrates the 3 cell towers that Becker's phone communicated with in the period of 12:47 to 1:17 p.m. And from this, chronological order can be used to determine the approximate location of Becker's phone at certain periods.
What does your diagram of possible locations demonstrate with regards to the crime, Detective Markowitz?
It suggests that it is highly likely that between 12:47, when Perkins' first call was placed, and 1:17, when the last call was placed, Avery Becker took the most direct route from their home to Brackman's home. After 1:17, at the last call, the phone stopped responding to cell towers entirely, which could mean that it was placed in airplane mode, shut off, or destroyed.
Thank you, Detective Markowitz. Your Honor, I have no further questions at this time.
Ms. Rowe, your witness for cross-examination.
Yes, Your Honor. What is your relationship with the case of Mackenzie Brackman's death?
Well, I'm the detective for it, so I'm investigating it.
How long have you been working as a detective?
7 years.
I would like to direct the witness to Exhibit 20. Do you know what this is?
Apologies, let me just.
Sorry, what did you say? You cut out for a moment.
Apologies, I'm just pulling it up.
Okay, sorry.
Yes, I do know what this is.
Would you say that this is a fair and accurate representation to the best of your knowledge of the report?
Yes.
Your Honor, I would like to ask permission to publish this Exhibit 20 into evidence.
Ms. Faulkner?
I have no objection, Your Honor.
Okay. In this report, the private investigator states that he believes the victim was likely stabbed from behind when he was unaware. Is this possible?
I concluded that it was more probable that he was stabbed from the back as he tried to escape the home.
Is it possible for the victim to have been attacked from behind?
It is possible for the victim to be attacked from behind.
If this is possible, then could there have been an entirely different outcome to the case?
Could you restate the question, or re-ask the question? I'm sorry.
If this is possible, could there have been a very different outcome to the case or a different motive for the case?
Well, it is possible in cases like this, we obviously were not at the crime when it happened, so we cannot be entirely certain it's possible, but I do believe my theory.
Moving on, you state that Brackman's history could indicate that an ex-client might have committed the crime, correct?
Apologies, can you repeat the question?
Yes. Moving on, you state that Brackman's history could indicate that an ex-client might have committed the crime, correct?
That was one of my original theories, yes, but when I followed up with the theory I have now, it did provide many leads.
When Alex came to the police department, did he have his cell phone on him?
No, which, it is a police interview. People tend to get nervous. I didn't think it was all too odd.
Yes, but is it unusual?
And Detective Markowitz, I don't know whether you answered that question. If you did, the court did not hear it. So is it unusual that a person would not bring their cell phone, I believe was the question.
It is an interview with the police and people can get nervous with that. So I would not think it would be too unusual for him to forget.
Moving on, I would like to direct the court and the witness to Exhibit 14. Okay, do you have Exhibit 14 in front of you?
Yes.
Do you know what this is?
Yes, these are the screenshots I was sent by Alex Cifuentes.
Is there any hard evidence that Avery sent those texts?
I'm so sorry. Can you repeat the question?
Yes. Is there any hard evidence that Avery sent those texts?
Well, I did have Alex Cifuentes testify or report to me, and I believe he testifies under oath here, that these screenshots were sent by Avery.
But is it possible that the screenshots were doctored?
Like all things, it is possible, but like I said, Alex Cifuentes has repeatedly testified that they were not.
I would like to direct the witness and the jury to turn to Exhibit 15, sorry. And do you have Exhibit 15 in front of you?
Yes.
Do you know what this is?
Yes. These are another one of the screenshots.
So the CDR shows that there are many calls and texts going to Avery Becker's phone on the day of the murder, correct?
Yes.
And could that correlate to Perkins calling Becker to search for her cell phone?
Objection, Your Honor. Facts not in evidence. Exhibit 15 has not been admitted yet into evidence. Opposing counsel will need to do so before questioning the witness about that document.
Ms. Rowe, response.
Okay, I would like to continue and ask permission to submit 15 into evidence.
Any objection, Ms. Faulkner, to admitting Exhibit 15?
I believe that proper foundation has not necessarily been laid to admit Exhibit 15, so I would object on only those grounds.
Okay. Ms. Rowe, I'll allow you additional time to question the witness if you wish, but at this time I am sustaining the objection. There has not been proper foundation.
Look at Exhibit 15. Can you please explain to me what this is?
Exhibit 15?
Yes.
This is a screenshot Alex Fuentes sent to me.
I believe we're talking about Exhibit 15. Is that correct?
Yes, we were talking about Exhibit 15.
Oh, I apologize. Yes. This is a record of the cell phone towers.
And do you have experience reading these cell phone towers?
Yes.
Okay. At this time, I would like to enter in Exhibit 15 into evidence.
Ms. Faulkner?
I do not believe that foundation has been laid to prove that this is an accurate representation of the diagram that Markowitz used in the process of her investigation.
Okay. Ms. Rowe, any response?
I would like to ask the witness one more question.
Certainly.
Is this a fair and accurate representation of the CDRs that you have?
Yes.
Okay, I would like to ask permission to enter Exhibit 15 into evidence.
Ms. Faulkner?
I have no objection, Your Honor.
All right. At this time, the court will receive Exhibit 15 into evidence, and you may constructively publish that to the jury, Ms. Rowe, if you wish.
I would like to direct everyone's attention to Exhibit 15 if they have not already. So this shows Becker's cell phone allegedly traveling towards Brackman's home, correct?
Yeah.
And does this necessarily mean that it was Avery who was carrying the phone?
I mean, the phone obviously is the one responding to the cell phone towers, so I cannot be entirely sure it was Avery. But
Excuse me, time's up.
Great. And Ms. Thayer, is that time for cross or time for direct that you are
Cross.
asserting? All right. So Ms. Rowe, time for cross has expired. I will, at this time, let me ask a point of procedure. Am I permitted to allow any redirect if there is remaining time on the prosecution's time for direct examination of witnesses?
I believe so, Your Honor.
I will permit the opportunity for redirect. So Ms. Faulkner?
Thank you, Your Honor. I do have a brief redirect of Detective Markowitz. Detective Markowitz, why did you choose not to investigate Blair Rollins?
with all respect, these theories seem like speculation to me. I've based my case on evidence and interviews and data I've collected, and this theory seems like armchair speculation.
Thank you very much, Detective Markowitz. Your Honor, the prosecution has no further evidence at this time.
Okay. And at this time, it will be the opportunity for the defense case. Would the defense attorney calling Avery Becker please call that witness to the stand? Oh, and Ms. Rowe, you are on mute.
The defense would like to call Avery Becker to the stand.
All right.
Would you please state your name and spell your last name for the record?
Avery Becker, Becker.
Why are you at court today?
I've been unfairly accused of murdering my coach, Mr. Brackman.
Who is Mackenzie or Coach Breckman?
So Mr. Brackman was my coach for all of my time at mock trial. We never got along with each other. He always wanted to be very nitpicky and would rewrite anything that we would.
Objection, Your Honor, speculation. The witness does not have personal knowledge under, I believe it's Rule 62 to testify to the exact personal feelings of Mr. Brackman.
And Ms. Rowe, I'm going to ask for your response, but just a moment. There was some interference with one person's mic who's unmuted. So if you could all just make sure to keep your microphones clear and free from interference. Ms. Rowe, response to that objection.
While she cannot testify to the inner feelings of Coach Brackman, she can attest to her observations of Brackman and her own direct personal experiences with him.
At this time, the court is going to overrule the objection. Mr. Becker was testifying that he described the victim as nitpicky and that the victim wanted to rewrite certain pieces for him. So I will permit the question. At this time, go ahead, Ms. Rowe.
Would you like me to restate the question?
Yes, please.
Who is Mackenzie or Coach Brackman?
Yes, so Mr. Brackman was our coach. We never got along. I liked to be more spontaneous and do things on the fly, and I could, because to me it's easier to write across for a witness just after listening to their direct. I think that mock trial should flow like that, and Mr. Brackman had different ideas.
What is your relation with Mackenzie Brackman? Oh, well, other than you being coached too.
Like I said, we would argue a lot and we just had different ideas about how things should be done.
How long have you been doing mock trial for?
I've been doing it all 4 years of high school.
How would you describe Coach Brackman's relationship with the other members of the team based on your observations?
Yeah, so Mr. Brackman would get down on all of us on the team. As I mentioned before, he would rewrite what we would send to him, and he was very critical. And so it wasn't just like him and me had a thing. He was critical to everyone on the team.
Describe the incident with Coach Brackman's car.
Yes, so it was not my finest moment at all. We had just gotten done with the regional tournament, and the practice after, we were going over what we had done well, and I had won awards, and I was just going to go over that, but Mr. Brackman just got on me once again, and he said some really horrible things, in my opinion, and I got so angry that I stormed out of practice, and I took with me what I thought was a dry erase marker, and I wrote worst attorney award on his white Porsche, and I feel so guilty about it, and I just wish I'd never done it in my anger.
Thank you. Where were you on the day of Coach Brackman's death?
Yeah, so on that day, I had realized that I had lost my phone, and so I decided to look for it with my best friend Taylor, and that's what we were doing.
What do you believe happened to your cell phone?
So the day before that, I was with Taylor at the Fry Shack, and we ran into some other members of the mock trial team. We had a conversation with them, and I think I left my phone there, and I think that anyone who was there could have taken it.
Who is Blair Rowlands?
Blair Rowlands was just another student at our high school.
And what was his relationship with Coach Brackman from what you could observe?
From what I've observed and heard, apparently Blair's dad had something to do with a case that His father was
Objection,
in.
Your Honor, this testimony is hearsay under Rule 801C. The witness is testifying to an out-of-court statement that appears to be going towards the truth of that statement, which is the foundation for the objection.
Okay. Ms. Rowe, response?
Yes, I don't believe that she is going to the truth of the matter. She's not accusing anyone. She's just telling the court what her observations were.
This time I am going to sustain the objection as a hearsay statement. Ms. Becker particularly testified that she had heard, presumably around school or around town, that this was how Mr. Rollins was involved with Mr. Beckman. Ms. Rowe, Brackman, excuse me. Ms. Rowe, you may continue your direct.
Moving on, who is Alex Cifuentes?
So Alex was another member on the mock trial team. He always had this weird thing that he would pretend that we were friends, but we definitely were not. We didn't get along.
So would you say that you and Alex were very close?
Not at all. We only saw each other at practice.
I would like to, at this time, direct the witness and the court to turn to Exhibit 14. And do you have Exhibit 14 in front of you?
I do.
Do you know what these are?
So these are apparently the texts that Alex think that I had with him, but I did not send these texts.
Again, for clarification, did you write these texts?
No, I wouldn't text Alex. He's not really my friend.
So would you ever confide in Alex?
Definitely not.
And lastly, did you have any access to Mr. Brackman's home?
No, he was just my coach, and I wouldn't want to try to start something with him after what happened with his car.
Moving on, could you please turn your attention to Exhibit 10? And do you have Exhibit 10 in front of you?
Yes.
Do you know what this is?
So this looks like the footage of the intruder walking up to Mr. Brackman's house.
And is this a fair and accurate representation of the footage from Mr. Brackman's house?
Yes.
I would like to ask permission to the court to publish Exhibit 10 into evidence.
Ms. Faulkner?
I have an objection to the admission of this exhibit. I do not believe under Rule 901 that it has been properly authenticated and identified by Avery Becker. Since Avery Becker was not an investigator in this case and only has knowledge through their lawyers, I do not believe that it is, this is really proper to authenticate this evidence through them pursuant to 901A in the mock trial rules of evidence.
And Ms. Rowe, any response to that?
Based on all knowledge given to us by the ones that gave us the exhibit, it is fair for any one of us to authenticate this as the real footage from Coach Brackman's house.
The court is going to sustain the objection. I don't believe this witness would have personal knowledge of whether this video is a true and accurate representation of what happened at Coach Brackman's house, unless in fact Mr. Becker is going to admit that he was there.
Yes, Your Honor. Thank you. No further questions.
Cross-examination, Ms. Faulkner?
Yes, Your Honor. One moment. Okay. Good afternoon, Avery Becker. It's good to talk to you. So during your time in mock trial, you didn't get along with Coach Brackman.
No.
And Brackman said that you didn't put in the work.
Yes.
You felt that Brackman never gave you really any credit for anything that you did.
No.
You felt that Brackman hated you, in fact.
Yes.
And you argued at almost every practice last year.
Pretty much.
He called you lazy.
He did.
And you told him that he wouldn't know a good cross if it hit him over the head.
He wouldn't.
nonetheless, you did tell him that?
I did.
About a month before regionals, Brackman removed you from the A team and sent you to the B team. Am I correct?
Yes, which made no sense.
And you were pretty upset about that.
Yeah.
You believed the B team was full of losers?
The A team has always been more professional than the B team, and I believe that I belong there.
Let's discuss your relationship with some of the other students in mock trial. So you and Taylor Perkins were pretty good friends.
Yeah, we're best friends.
And you joined mock trial to hang out with Taylor and play on your phones.
Yes, it did start like that, but soon I learned to love mock trial.
And Taylor Perkins quit the A team in order to help you restore your position when Brackman demoted you before regionals.
Yeah, like a true best friend.
And your team did well at regionals.
We did.
And you took a lot of pride in the awards that you won.
I think that I deserved every award that I got.
And at practice after the regional competition, Brackman argued with you in front of the whole team.
Yes.
He said that you didn't deserve the Best Attorney Award.
Yes.
And Brackman said that your closing statement specifically was just lucky.
Yes.
And he, in fact, told you that you would cause the whole team to look bad and lose its state if you didn't put in a lot more work.
Yes.
And you called him the worst coach in the state after that?
After all of the things that he said that you just mentioned, I was so angry that I would say anything to him.
You stormed out of practice, even.
I did.
So I'd like to move on to the day that Brackman was murdered, March 6, 2020. You claim that you noticed that your phone was missing, that you noticed your phone was missing on the morning of March 6th after waking up.
Yes.
And you claim that you skipped school with Taylor to search for your phone.
Yeah, we had first period off, so we just decided to look for it.
And you liked using your phone.
Yeah.
You, in fact, had initially joined mock trial to use your phone with Taylor.
Yeah.
You didn't notice that your phone was missing for over 12 hours, Miss Becker?
I did not.
And you'd never made an effort to digitally locate that phone using iCloud or another feature.
I think that I was so freaked out about finding it that some of those logical ways that I could have found it just escaped my head.
Thank you, Miss Becker. In fact, the only way you actually tried to locate your phone was to look all over at the mall and the Fry Shack and then to have Taylor call you.
Yeah, we went back to where I had last remembered having it.
And the only person who claims to have seen you at the time that Brackman was murdered is your friend Taylor Perkins.
Yes, because we were together.
Let's move back to the practice after regionals. So when Brackman kicked you off the team, you noticed his, quote, obnoxious white Porsche.
Yes, it even has the litigator license plate.
And you wrote Worst Attorney Award on the hood of his Porsche.
Unfortunately, I did.
You thought that this would show Brackman what you really thought.
I don't know what I was thinking. I was just so angry that I just needed to do something about it.
You never checked to see if the marker you were using was permanent.
I did not. I thought it was dry erase.
And you knew he loved this car.
Yeah, that's why for some reason my mind wanted to write on it.
And did Brackman yell at you when he noticed his car?
He did, which makes sense.
He said he'd had enough of your crap.
Yes.
He said you screw around in practice and are disruptive.
Yes.
And he kicked you off the team.
Yes.
He told you that you could, quote, join that loser Taylor Perkins and play video games all the time.
Yep.
Which made you even madder.
Yeah.
And after you went home, your mother told you that he had kicked you, or rather, you told your mother that he had kicked you off the team for no good reason.
Yes.
You told her, in fact, that you would get back at him if it was the last thing you did.
Like I said, I was so angry, and throughout all of that, I think I was just doing things that I totally regret later and saying things that don't even make sense to me now.
Thank you, Your Honor. I have no further questions at this time.
All right. Ms. Rowe, redirect?
No redirect, Your Honor.
All right. May this witness be excused, Ms. Rowe?
Yes, Your Honor.
All right. Then we have the second witness is going to be, let me double check my notes here. Sorry about that. Would the defense call their second witness?
I would like to call Taylor Perkins to the stand, please.
All right. You can go ahead and begin your direct.
Thank you, Your Honor. Good afternoon, Ms. Perkins. Could you state your full name and spell your last for the record, please?
Taylor Perkins, Perkins.
And why are you here today, Ms. Perkins?
I need to prove my best friend Avery's innocence. She has she's been wrongfully accused.
And who's Avery?
She's the defendant, of course.
Now, you say you need to prove Avery's innocence. Do you have a close relationship to the defendant?
Of course, we're best friends.
So, seeing as you and Avery are best friends, from your observations, how well would you say you communicate with Miss Becker?
Perfectly. She told me everything.
Everything. So you would say from your observations that you have a pretty solid idea of Miss Becker's character.
I definitely do. She was egotistical, but mock trial was way more important to her than her ego or reputation.
So Avery was on the mock trial team with you. How did she perform?
She was amazing. She was really natural at it. Even unprepared as she was a lot of the time, she would just do perfectly well. She even won Best Closing and Attorney in the tournament last year.
Thank you, Miss Perkins. And it appears from your witness statement that Avery and Coach Brackman had a bit of a rivalry. Is that accurate?
They definitely did. A lot of it was just petty arguments that really made me laugh. I thought they were super funny, but there were times where Brackman was just immature and Avery had to stand up for herself at some point.
And what did...
I'm sorry?
Objection, Your Honor.
On what grounds?
Improper characterization.
Okay. Mr. Cameron, your response?
I ask that the prosecution please elaborate upon their objection so I can have a better idea of their problem.
Ms. Martin?
Yes. Under 403, the statement towards Mr. Brackman's immaturity and how it was proper for the defendant to respond in a certain way is unfair and dangerous, and its probative value is substantially outweighed by the danger of unfair prejudice that is confusing and misleads the jury. Furthermore, it leads to speculation towards how Mr. Brackman's reaction was.
Mr. Cameron?
Well, I believe that this response can be permitted as Miss Perkins is just talking about her experience with Mr. Brackman and her opinion of him. She's not necessarily saying anything that she believes to be untrue. She's not misleading the jury as she is being honest about her own opinions.
The court is going to permit limited inquiry into Ms. Perkins' particular experience with Mr. Brackman. So I'm going to overrule the objection at this time. She can describe her interactions with him and how she felt.
Thank you, Your Honor. So just moving on, allow me to restate the next question. What did interactions between Avery and Coach Brackman look like regularly?
He was always tearing into her about something. He was overly critical of her at times. It was pretty awful.
I see. And did Avery ever retaliate to these criticisms?
She did once. During one of our meetings, he was just ripping into her, and understandably, she got angry. And so she grabbed a marker, not knowing that it was permanent, and wrote Worst Attorney Award on his Porsche.
see. And from what you observed personally, how did it appear that Avery felt about this decision?
She felt awful about it. She apologized to him over and over, but he wasn't having it and ended up kicking her off the team.
Thank you. And Ms. Perkins, it says in your testimony, as well as that of the defendant, that you two were together on the day before the murder. Is that correct?
I believe that is correct, yes.
And what were you and the defendant doing that day?
We were just hanging out.
Okay. And you say in your statement that you went to the Fry Shack and some of the other team members were there. Is that correct?
Yes, that is true. We did go to the Fry Shack.
And did you have any interaction with these team members?
We did for a little bit. We just talked about how unfair it was that Avery was kicked off the team.
And did it appear to you that everybody felt that Miss Becker's removal was unfair?
Well, almost everybody. There was one person who didn't look sincere at all, and that was Alex Cifuentes.
Alex Cifuentes was a member of your mock trial team?
Yes, he was.
So was the defendant close to Alex Cifuentes as far as you observed?
No, not at all. In fact, Alex really didn't like her.
Thank you. And what was Avery doing when you were talking to the rest of the mock trial team?
Well, she got upset, understandably. I mean, we were talking about her failure to come back on the team, and so she set her phone on the table and went to the bathroom.
And did she have her phone with her when she went to the restroom as far as your observations?
No, she did not.
Did she have her phone when you two left the Fry Shack?
I believe that she did not.
It states in your witness statement that you believe Alex Cifuentes took the phone. Is that correct?
Oh, definitely. He totally hated her.
Objection, Your Honor. Improper characterization. Under 404A1, evidence of a person's character or character trait is not admissible to prove that in a particular occasion that they acted in accordance to that character trait.
Mr. Cameron, response?
Your Honor, I do agree with the prosecution in this case that it was improper to say that Alex Cifuentes hated Avery Becker, but I would ask that the witness be allowed to testify as in a more limited setting as to what Mr. Cifuentes' opinions of Avery Becker were as far as her observations permit.
I'm going to sustain the objection. As far as the next question that you asked, Mr. Cameron, we'll see if that garners an objection as well.
Okay, thank you, Your Honor. It also states in your witness statement, Ms. Perkins, that you believe that Alex Cifuentes gave the phone to Blair Rollins. Is that correct?
Objection, Your Honor. This is speculation. There is no evidence, and under Rule 402, the question is asking for the witness to testify towards evidence and testimony that is not either that has not been introduced to be sufficient enough for the witness to talk about this matter.
Mr. Cameron, response?
Your Honor, I am not asking the witness to testify as to whether or not Mr. Cifuentes gave the phone to Blair Rollins. I am merely asking her to state if she said such in her witness statement. My question specifically says, can you confirm or deny whether or not this is in your witness statement, not if she truly believes that statement?
Okay, and Ms. Martin, any response to that?
Yes, Your Honor. Whether or not it is being confirmed about whether they said this in their witness statement, it is still speculative. Furthermore, I also will object to this being a leading question, as it is not open-ended and is asking for a specific yes or no answer.
I am going to sustain the objection. It is leading, and this is direct examination. So at this time, I am not going to permit the question or the witness's answer. Mr. Cameron, you may go ahead and continue your direct.
Okay, thank you, Your Honor. so just moving on. Miss Perkins, at what point did you and the defendant realize that Miss Becker's phone was missing?
The day after.
And by the day after, you mean March 6th, this being the day of the murder?
Yes, it was.
What did you and Avery do that day?
We were desperately trying to find her phone. I mean, it was like her third kidney. She was totally freaking out.
For how long were you looking for the phone?
The whole day.
So on March 6th, the day of the murder, you and Miss Becker were looking for Miss Becker's phone at the mall all day.
We were.
Thank you. No further questions, Your Honor.
Right. Ms. Martin, cross-examination.
Yes, Your Honor. Now, Miss Perkins, you consider yourself to be Avery's best friend?
Yes.
You were on the same mock trial team together?
Yes, we were. She was the only reason I was there.
You were only on mock trial because Avery did it?
Yep, she was my best friend.
Looking at the dynamics of the team, in your opinion, Mr. Brackman didn't like Avery because she put in little effort?
That is true.
And she did not try hard enough?
That is also true.
And never came prepared?
She did not, but she was still better than everybody else.
But yet she nonetheless never came prepared?
Yes.
And in your perception, that drove Mr. Brackman crazy?
It totally did.
So crazy that sometimes Mr. Brackman would get so mad that you could swear you could see steam coming out of his ears?
Yeah, it was pretty funny.
And yet you found their feud kind of funny?
Yes, I did.
But the feud really bothered Avery?
It did, the worst parts of it.
Bothered her enough to play some pranks on the coach?
Yeah, but I mean, who wouldn't?
You even agree that Avery could be rash?
At times, but mock trial was way more important.
And Avery, you also agree that Avery had an inflated ego?
She did, but again, mock trial was more important than that.
Let's talk about the practice about a month before the regional tournament. Avery came to practice the most unprepared you'd ever seen?
Yep, but still better than everybody else.
Nonetheless, she was very obviously making things up on the fly?
Yep, she was talented though.
And in your perception, Mr. Brackman once again got heated?
He did.
So heated that Avery was demoted to the B team?
Yeah, it was pretty unfair.
And a week before regionals, you quit the team to support Avery, correct?
I did, but it didn't matter to me anyway.
So you quit the team so Avery could return to the A team?
Yeah, but I wasn't mad about it.
Moving on, you were not there to see what happened at the practice where everything blew up.
I guess I wasn't.
But you only heard about it from Avery?
Yes.
And according to Avery, apparently Coach Brackman was giving her a hard time?
Yes, but it makes sense. He would always do that anyway.
And Avery once again got upset?
Yeah, at this point, I would too.
And on the way out, Avery saw Mr. Brackman's beloved Porsche?
Yes.
And Avery decided to write Worst Attorney Award on the hood?
She did, but she didn't know it was a permanent marker.
Nonetheless, she still decided to write on the car, correct?
She did.
And it was with permanent marker?
Yes.
And after this, Mr. Brackman kicked Avery off the team?
He did.
Moving past this, on the night of March 5th, or on the day of March 5th, you and Avery went to Fry Shack?
That we did.
And then you both went and hung around the mall?
We did.
It wasn't until the morning of March 6th that Avery realized her phone was missing?
Yes, and she was going crazy trying to find it.
Avery didn't realize her phone was missing for over 12 hours?
She didn't. We all make mistakes.
Despite the fact that in your eyes, Avery's phone was like a third kidney?
Again, she was desperate trying to find it. But yes.
And in your eyes, her phone was never out of reach.
Usually not.
And when you realized the phone was missing, you ditched school on March 6th.
We had first period off, but yes, we did.
The same day Mr. Brackman was murdered.
Yes.
And you ditched school to retrace your steps.
We did.
You went to the mall.
Yes.
Checked each store you gone to.
Yes.
Even went back to the fry shack.
We did.
You texted and called the phone several times.
I did, and we couldn't find it.
You burned the entire day searching for it.
Yes.
Yet, in minutes, you could have found Avery's phone if you'd used the iCloud website.
I suppose so, but we were both freaking out about it.
So you burnt an entire day searching and calling Avery's phone, but never thought to use the iCloud website.
No, we did not.
And so you never used it.
No.
Thank you, Your Honor. No further questions.
Any redirect of this witness?
Not at this time, Your Honor.
All right. May she be excused?
Yes, the witnesses can be dismissed.
All right. And then for the defense, would you call your third witness, please?
We call Detective or Professor Blake Van Owen to the stand. Sorry.
Right. And Ms. Erickson, you may go ahead and begin your direct.
Thank you, Your Honor. So, Detective, please state your full name and spell your last name for the record.
Blake Von Owen, Owen.
And can you explain your job, Professor?
I am a private investigator, a professor, and an expert witness.
And can you give us some context on your private investigation? Sorry.
I used to be a police officer at the Aurora Police Department, but left due to an injustice in the system. Afterwards, I then went to become a school officer, a private security guard, and then went into private investigation, which I learned a lot about social justice and police policy, and I now teach about social justice and police policy and have been for 5 years.
Thank you. And what is your experience in being an expert witness?
I've been an expert witness in Colorado, Arizona, and Nebraska, and in an expert witness in the state districts of Colorado, New Mexico, Nebraska, and Wyoming.
Thank you. Your Honor, at this time, I would like the court to recognize Professor Blake Van Owen as an expert in crime scene reconstruction, cell tower analysis, and general police investigation tactics.
All right. And which prosecution attorney is going to be doing the cross-examination of Professor Von Owen?
That would be me, Your Honor.
All right. Ms. Jupiter, any objection to Professor Von Owen being declared a witness, an expert witness in those fields?
Yes, Your Honor. Permission to conduct a voir dire.
You may.
Professor Van Owen, since leaving the police department, you have not worked as a police officer since.
No, I have not.
And since then, you also have not been exposed to police training nor protocol.
I have studied police policies for 5 years.
You have not received any specializations, outside of your master's degree in criminal justice.
You're correct.
You also do not have any formal education in crime scene reconstruction.
No.
So you have not sat in a classroom and learned about crime scene reconstruction.
But I have learned about police policy and have been an expert witness multiple times.
Do you have any formal education surrounding cell tower analysis?
No.
Cell towers and crime scene reconstruction are not part of the curriculum you regularly teach, is that correct?
That is correct.
Your Honor, I do object to Professor Van Owen being admitted as an expert witness in crime scene reconstruction, cell tower data analysis, and as this witness lacks the sustained experience and formal specialized education in these fields.
Any response, Ms. Erickson?
Yes, Your Honor. The professor has testified that she has had experience as an expert witness multiple times in these three fields, as well as continuing her study of the field despite not having experience in it. And I think that is enough to qualify her as an expert now.
Court is noting the objection of the prosecution. I am going to permit Professor Von Owen to testify as an expert in the areas of crime scene reconstruction, cell tower data analysis, and police investigation, recognizing that she has been so recognized in other courts. Ms. Erickson, you may continue your direct.
Thank you, Your Honor. So to begin, what have you reviewed pertaining to this case?
I've reviewed the police reports, the investigation, and the reconstruction led by Kyle Kuzak, as well as the cell tower reconstruction by Detective Markowitz.
And what is your expert opinion on the reports you have reviewed?
Personally, I'm a little unsatisfied with the evidence laid before us today, with the unprofessional behavior of Kyle Kuzak and the missing images of the bloodstains and cast off, as well as the lack of information about Alex Cifuentes' screenshots and the cellular tower database.
So won't you tell us more in detail, beginning with Kyle Kuzak's reconstruction of the crime scene?
Mm-hmm. According to Kyle Kuzak, he believes that the intruder went into the house, and Mr. Brackman, after hearing the intruder, went to the kitchen, got a knife from the knife block, and then went to the intruder. They both had a struggle. After the struggle, the intruder stabbed Mr. Brackman and left through the front door.
And what physical evidence shows us this?
For Kyle Kuzak, he believes that the knife was from the knife block, and then the stab on the behind, and the skid marks on the floor.
And what physical evidence do you see in this?
Personally, I see that the knife could not have been from the knife block, as it doesn't match any of the other knives in the knife block. The skid marks, you can't carbon date skid marks. You don't know when where they came from. So they didn't necessarily come from the struggle and could have been from any time previously.
And so based upon this, was Kuzak's conclusion completely accurate?
I don't think so, as well as the stab wound on the back of Mr. Brackman at the direction that the intruder would have held it. It would have had to have been above Mr. Brackman. However, the intruder, as in the videos we've seen today, shows that the intruder was of average size and weight. Therefore, Mr. Brackman must have been sitting down, while the intruder had to have been stabbing him from behind and above.
And so, on the subject of those videos, what opinion do you have on Detective Markowitz's analysis on the Ring doorbell videos?
Notifications can be turned off, especially in the afternoon, and we have no physical proof or evidence that the notifications were or were not turned on or off. The Detective Markowitz thought that it would not be suitable to collect this database. So,
Objection, Your Honor.
What's the basis of the objection, Ms. Jupiter?
This witness has testified to speculative information. This witness would not know what Detective Markowitz was thinking at the time of her investigation, and therefore cannot testify to it without doing so in a speculative manner.
Ms. Erickson, any response?
Yes, Your Honor. This witness, in her experience of police investigation tactics, would have knowledge of what an what a detective would be likely to be thinking of based upon the path that they take concerning the evidence.
This time I am going to sustain the objection on speculation and lack of personal knowledge of the detective's thoughts. Certainly the witness may testify to general crime scene investigation process as she has been so qualified.
Thank you. Moving on, in your expert opinion on both police procedure and cell tower analysis, what is the evidence concerning Avery Becker's phone?
You can't locate an exact location for a phone, and you can't tie a person to the phone. We have no physical evidence that Avery Becker was with her phone. And in fact, we do have witnesses attesting that she was without her phone. So we have the evidence that we've given that Avery Becker might have been with her phone is faulty, and there's no liability in it.
So how credible is the evidence linking Avery's cell phone to the scene of the crime?
You can link the cell phone to the crime, but you cannot link Avery Becker to the crime, as well as you don't know who had the phone at the time.
And what conclusions can you make from this information?
There's no reliable evidence saying that Avery Becker was there, therefore that the cell tower information can't be used as evidence for this case.
And do you have any further objections to the procedure of the investigation reports that you reviewed?
Yes, motive seems to be a very big point in all cases that I've seen. And here it does not seem that Avery Becker had proper motivation previously. The vandalism does not equal murder.
And so did you investigate further based on this motive?
Yes, I did look into several other of Avery Becker's classmates and found more cases that tied Mr. Breckman.
And what was one case?
The case of Jonathan Rawlings, in which Mr. Breckman was the lawyer for.
And what evidence can you bring from that investigation?
It seems Jonathan Rowland's son, Blair Rowlands, was at the same case and in the same grade as Avery Becker. He was gone on the day of school after further investigation, and after the case of Jonathan Rawlings, Jonathan cried out that Mr. Breckman would die. And so we can see from that it seems that Blair Rawlings had far more motive than Avery Becker would have.
No further questions, Your Honor.
All right, Ms. Jupiter, cross-examination?
Yes, please, Your Honor. Professor Van Owen, in more than 100 cases, you have always testified for the defense.
That is true.
And as a private investigator, you were hired by the defendant in this case, is that correct?
That is also true.
You also made $225 per hour for your investigation work.
Yes.
You made $225 per hour for your research on this case.
Yes.
And you expect to be paid an extra $450 per hour to testify for the defendant today, is that correct?
That is correct.
Objection, Your Honor. Relevancy?
Ms. Jupiter?
Yes, Your Honor. I believe this information is relevant because it goes to show the nature of the relationship between the witness and the defendant, as well as the witness's connection to this case itself.
I'm going to overrule the objection at this time. I do find that this question is relevant as it might show the witness's possible bias, and the jury certainly can consider that. Ms. Jupiter, you may continue your cross.
Thank you, Your Honor. You expect to earn approximately $8,000 total for your work with this case.
Yes.
That's quite the payday. Moving on, is it true that you left the police department after an incident during an arrest?
Yes,
And you were sued over this incident?
indeed I was.
Moving on, I would like to ask a few questions about your investigative work. You never visited the crime scene for this case, did you?
No, I did not.
You simply reviewed the police reports?
Yes, and everything else that came along with it.
You simply reviewed Mr. Kuzak's reconstruction report?
Yes.
You simply reviewed Detective Markowitz's report?
Yes.
You also admit that holding a knife the way you suggest the assailant did in your report is uncommon?
Yes.
You also did not obtain the cell tower records of the day prior to the murder to corroborate the defendant's alibi, is that correct?
Yes.
And you made $8,000 for this work?
Indeed I did. I'm a professional.
Thank you, Professor Van Owen, and thank you, Your Honor. I have no further questions.
Ms. Erickson, any redirect?
Yes, Your Honor, a short one. So, Professor, this incident that the prosecution mentioned, can you explain it further?
Could you raise?
I'm sorry, everybody kind of spoke at the same time.
Yeah, my bad.
Can you ask the question again, Ms. Erickson?
Yes, my apologies. This incident in which you were sued and left the police department.
I accidentally injured a young Black woman in an arrest. And though I will never forgive myself for doing so, the police did. And under that injustice of the system, I have further decided that I must bring the police to truth and not allow such injustice ever happen again.
And so, Professor, what is your motive in testifying in this case?
I want to bring out the truth and not have the quick and flimsy evidence that the police and detectives bring before us undermine the truth of the evidence.
Thank you. I have no further questions, Your Honor.
Ms. Jupiter, any recross based on that redirect?
Not at this time, Your Honor.
All right. I believe that is the defense's final witness. At this time, Ms. Fortner, I believe you're giving the closing for the prosecution. Is that correct?
That is correct, Your Honor.
All right, you may proceed.
Before I begin, I'd like to reserve all remaining time for rebuttal. Thank you, Your Honor. I'll get back at him if it's the last thing I do, were the words of the defendant in this case, mere days before brutally murdering Mr. Mackenzie Brackman in his home. Members of the jury, you are here today to answer a simple question. Who killed Mr. Mackenzie Brackman on March 6, 2020? In this case, the defendant had a motive and intent to hurt Mr. Mackenzie Brackman, along with a demonstrated history of impulsivity and vengeful, rash behaviors. During their time in mock trial, there were constant arguments between the defendant and the victim. At mock trial practices, the defendant was consistently underprepared for practices, relying on their good looks and improvisational skills to complete tasks on the team, which left the members as well as the victim in a state of constant anxiety. Ultimately, the victim kicked the defendant off the mock trial team for their constant bad behavior and arrogance. As the defendant themselves testifies, they had an enormous argument with Coach Brackman just after the regional competition, in which they called him the worst coach in the state. Immediately after this incident, the defendant wrote Worst Attorney Award across the hood of the victim's Porsche in permanent marker, leading to yet another massive argument. After this incident, the defendant told their mother they would get back at him if it was the last thing they did, texting Alex Cifuentes shortly after with their plan to trash the victim's house. The defendant denies having sent these text messages, despite the fact that Cifuentes provided screenshots of the messages to the investigators in this case, and has testified under oath to having received these messages personally from the defendant. The defendant clearly had a motive and an intent to commit the charge of second-degree burglary of the victim's dwelling prior to March 6th. The evidence of this intent continued on the day of the crime. The defense claims that the defendant missed school in order to search for their lost cell phone. However, both Perkins and Becker have also testified that the defendant was extremely attached to their cell phone. Perkins even refers to the cell phone as Becker's third kidney. It is basically impossible that the defendant would have lost their phone early in the evening of March 5th and completely failed to notice until the morning of March 6th. This is one of the many discrepancies in the defense's theory of the case. Additionally, Detective Jordan Markowitz of the DPD has testified that the defendant's call detail records are consistent with a route connecting to fully 3 towers in a row that would lead them directly from their dwelling to the victim's dwelling. Members of the jury, that means that according to their own cell phone, shortly before Mr. Brackman's death, Avery Becker was driving to his house. Attendance records at CHS also show that Avery Becker was absent from school on March 6th. And the only person who claims to have seen the defendant at the time of the murder is their friend, Taylor Perkins. As you've heard today, Kyle Cusack, a crime scene reconstruction expert, has shown that Mackenzie Brackman's death is consistent with a crime committed in the furtherance of the crime of second-degree burglary of a dwelling, qualifying it as a voluntary instance of felony murder. In this case, the prosecution must prove beyond a reasonable doubt that the defendant, Avery Becker, committed second-degree burglary and felony murder. The testimony you've heard today provides ample evidence to prove that the defendant had a motive, a history of rash behaviors, and a demonstrated intent to commit the crime. The defense has tried to raise the specter of an alternate suspect named Blair Rollins in this case, but their entire theory is based on speculation, since their hired gun, Blake Van Owen, chose not to pursue any real evidence related to his suspect and instead continues to focus on baselessly discrediting Mr. Cusack's, an oversimplified version of Mr. Cusack's work. Their theory comes down to speculative claims of cloaks and daggers, while there is concrete evidence for convicting Avery Becker. We are left with a simple question of who killed Mr. Mackenzie Brackman, and it is unclear who could have killed Mackenzie Brackman besides Avery Becker, his longtime rival who promised to get back at him if it was the last thing they did. Members of the jury, the evidence is proof enough to convict the defendant of the charges against them. Vote in favor of convicting Avery Becker. Thank you.
And I do see, Ms. Faulkner, that you have 30 seconds remaining.
Thank you very much.
Right. For the defense, I believe, Ms. Erickson, you're giving the closing.
Yes, Your Honor. Ladies and gentlemen of the jury, the opposing counsel has efficiently told you their facts, their story. They ask that you follow the path they have set and find the young girl, Avery Becker, guilty of the weighty crimes of burglary and murder. My co-counsel and I stand on the principles of complete truth and justice, however, and have provided to you the facts, all of them, and ask you to decide the story. We do not lay a path out for you and encourage narrow-minded adherence to said path. No, the case we have today is no single path, it's a spider web of evidence. To ignore any evidence in making your conclusions, ladies and gentlemen, would be to violate your duty as jurors. Opposing counsel holds the burden of proof and has furthermore failed to present sufficient evidence required to prove beyond any reasonable doubt that my client is guilty. Firstly, I ask you to consider the possible motives of all the people involved in this case. I admit, and Avery herself admits, that she was not fond of her mock trial coach, Mackenzie Brackman. However, have you not seen evidence supporting the fact that she was away from the scene of the crime, searching for her lost phone with her friend Taylor Perkins? Furthermore, there are other people with other motives involved. Alex Cifuentes claims to be as close to Avery as really good friends, yet both Taylor Perkins and Avery herself have claimed the opposite. Ladies and gentlemen, you cannot simply choose to accept Mr. Cifuentes' word over my client's. Alex, with his possible bad relationship with the defendant, has also the possible motive to frame her for a crime she did not commit. Both possibilities cannot be overlooked. Another person with a substantial motive to committing the crime herself, Blair Rollins, is not even present here today. To have one's father convicted, fueling one to revenge is at least worth investigation, if not a much stronger and much likelier motive to such a weighty crime as murder. This, ladies and gentlemen, can be explained by the inadequacy of both Detective Jordan Markowitz and Kyle Kuzak's investigations. Evidence has been ignored, lost, and unjustly connected to wrongfully condemn Avery Becker. You heard from Blake Van Owen, the two investigators' failure to consider all the evidence and their failure to find the whole story. Furthermore, you heard from Taylor Perkins evidence to show that Avery Becker lacked motive and so was incapable of committing the crime. Close friend to Avery, Taylor gave you all a testimony that highlights the guilt Avery felt after ruining her coach's car and her attempts to rectify her mistake of anger. How can one who feels the guilt of vandalism hold themselves together with the guilt of such a substantial crime as burglary and of murder? Avery as well only shows motive to returning to the mock trial team, not committing such a weighty crime. Ladies and gentlemen, you must be convinced beyond any reasonable doubt that Avery committed the crime of murder in the first degree and second degree burglary in order to find her guilty. If the web of evidence does not prove to you definitely of my client's guilt, it is your duty to find her innocence. Thank you.
Thank you, Ms. Erickson. And Ms. Fortner?
Thank you, Your Honor. Becker testified in court today that after their argument with Brackman, they were so angry they could have said anything to him. Avery Becker is prone to episodes of blinding rage. Follow the defendant's anger, members of the jury. Follow the evidence. Follow the defendant's own words and vote to convict Avery Becker. Thank you very much.
Thank you. To everyone, thank you very much for a very compelling and very prepared presentation of each side of the case. I am quite frankly blown away by the work that you guys are doing, particularly in the times that we are living in. And so the fact that you are able to do this and not just do this well, but do this well on a virtual platform is pretty impressive. Let's see what our scorekeepers have to say. Ms. Lilly, Ms. Ross, Mr. Ringenberg.
If it's okay, I guess I'll start. So first, I'll just say congratulations, everybody, for making it this far. You've done a great job. I concur with Judge Ellison. You've done a great job in presenting in such a difficult time and climate. I think that overall, you've done a really good job with the case. You were both very equally matched and presented the positives that you could for each side and highlighted the negatives for the other side very well. The only thing I would say is be careful about some of the commentary when you're asking questions. Sometimes that can seem a little unprofessional and can come off not only poorly to a judge, but also to a jury. Otherwise, I think everybody did a great job and you should be really proud of yourself. Thank you.
I too thought everybody did a really good job. And I really liked the witnesses. They were very emotive.
Ms. Ross, you are very faint. Is there a way that you might be able to speak up just a little bit?
Is this better?
That is better. Yes, thank you.
It was behind my back. I was saying that I thought everybody did a very good job. I thought the witnesses were very good. They were emotive and they were, I liked their facial expressions and their conviction in what they were saying. And then the attorneys were also very good with the voir dire and the questions that they asked and focused. The only thing that I would stay away from is asking the questions that were already answered. If it's already been stated from a previous, just mark that off your list and go on to the next one. But I thought everybody did a very good job.
Mr. Ringenberg?
Yeah, well done to all the witnesses and attorneys. I know this was probably not an easy experience and it probably took a lot more time than even a normal year. So props to you. My recommendation, I guess, would be sometimes it felt a little, and this should be a little bit lighthearted, right? Because it is supposed to be fun, but it sometimes didn't feel like there was the weight of a murder trial in front of us. And so some of the witnesses were great, but it also felt like it wasn't taking it like a murder trial that you'd hope to if you were a juror or different things. Totally agree with what the previous jurors have said so far, but yeah, well done.
And then I'd just like to follow up with a couple of specific, it's general to everybody, but just a couple of specific, both positive comments. And then just, I'd like to echo Ms. Ross's comment. Listen to your witnesses, and witnesses, listen to your attorneys. I know you guys know this case really well, and I know you've done it a lot and you've practiced it a lot. But if an attorney asks for your name or your age, don't then go into your profession and your experience. If the witness has already said that they've worked for a certain number of years, or if they've been a student on the mock trial team for a certain number of years, you don't need to then ask that on cross-examination. So just make sure that you're keeping in mind, I know that a lot of this, you guys have it worked out and you have all your questions down and you want to answer or ask all your questions. Make sure that you go through as you're listening to the witness and marking off the ones that they're answering during their direct. I think everybody did a phenomenal job, quite frankly, knowing the case. And when I ruled against you or for you on an objection, I think everybody did a really nice job of picking up, either restructuring the questions so that it would be admissible and it would be allowed, or deciding that that one was not worth the fight, or that you weren't going to use your time on that question and moving on. So I think that you really did a great job, and that's kind of the spur of the moment things that you have to do here. Everybody, I know that sometimes you do read some of the things that you're doing, especially if you're portraying a particular witness. Make sure you just breathe. Sometimes some of the testimony got a little bit fast, and I was trying to keep up with some of the notes, but I think you guys all did just a phenomenal job. Congratulations to all of you and to your coaches and to your schools for supporting you, but just a really, really great job. I'm very impressed. You can come work in my courtroom anytime. Oh, you're on mute.
You know, I think someone's going to make a killing with T-shirts that say that if one's going back to work. T-shirt that says, "Oh, you're on mute." Thank you, everyone, for your participation and for volunteering, Your Honor, and the scoring panelists. I'm going to turn the live stream off, and I'm going to wait for the coordinators to let me know that they've received all the scoring sheets, and then we can let the scoring panelists go. But I believe, Your Honor, that